Hello, everyone, and welcome to today's session on F for Corporate and Business Law. In this module, we explore the legal frameworks that govern businesses and corporations globally. Today, we'll focus on court-based adjudication and alternative dispute resolution (ADR) mechanisms. These are essential tools for resolving disputes, whether they arise within a business context or between international parties. Let's start by understanding the objectives of this session. To understand how court-based adjudication works. To explore the role of international courts in resolving disputes. To examine alternative dispute resolution (ADR) mechanisms, including arbitration, mediation, and conciliation. To delve into the UNCITRAL model law on international commercial arbitration, which standardizes arbitration practices globally. First, let's talk about court-based adjudication. This is the traditional method of resolving legal disputes through the court system. In most countries, courts are organized hierarchically, with lower courts handling minor cases and higher courts dealing with more serious matters and appeals. For example, in the English court system, there are separate structures for civil and criminal cases. Let's take a closer look at these structures. The English court system is divided into civil and criminal courts. These courts operate at different levels, with higher courts handling more complex cases and appeals. Let's explore the civil and criminal court structures in more detail. This diagram illustrates the hierarchy of civil courts in England. Here's how it works. County court. This is the lowest level of civil courts, handling local civil cases such as small claims, contract disputes, and family matters. High court. This court deals with more significant civil cases, including complex commercial disputes, bankruptcy, and judicial reviews. It has 3 divisions. O Queen's Bench Division, QBD, handles contract and tort cases. O Family Division deals with family law matters. O Chancery Division focuses on business, property, and trusts. Court of Appeal, Civil Division, this is the main appellate court for civil cases. It hears appeals from the High Court and County Court. Supreme Court, the highest court in England. It deals with cases of significant legal importance. It hears appeals from the Court of Appeal and, in some cases, directly from the High Court through a leapfrog procedure. European courts. At the top of the hierarchy are the European Court of Justice, ECJ, and the European Court of Human Rights, ECHR, which handle cases involving EU law and human rights, respectively. This diagram shows the hierarchy of criminal courts in England. Magistrates' Court. This is the lowest level of criminal courts, handling minor offenses, summary offenses, such as traffic violations and minor theft. It also deals with preliminary hearings for more serious cases. Crown Court. This court handles serious criminal cases, indictable offenses such as murder, rape, and robbery. It also hears appeals from the Magistrates' Court. Court of Appeal, Criminal Division, this is the main appellate court for criminal cases. It hears appeals from the Crown Court. Supreme Court, the highest court in England. It deals with criminal cases of significant legal importance, often involving complex points of law. European courts. Similar to the civil structure, the European Court of Justice, ECJ, and the European Court of Human Rights, ECHR, handle cases involving EU law and human rights, respectively. Now that we've seen how the court system is structured, let's discuss the advantages and disadvantages of court-based adjudication. Advantages. Enforceable solutions. Courts can issue binding orders, such as compensation or injunctions. Legal precedents. Courts create precedents that guide future cases, especially in common law systems. Disadvantages. Costly. Legal fees and court costs can be high. Time-consuming. Cases can take years to resolve, especially if appeals are involved. Next, let's discuss the role of international courts. These courts are crucial for resolving disputes that cross national borders, especially in international trade and commerce. 2 key international courts are European Court of Justice, ECJ, this is the highest court in the European Union, resolving disputes between member states. International Court of Arbitration. ICA, this body oversees international commercial arbitration, ensuring that disputes are resolved fairly and efficiently. These courts help resolve conflicts of law and enforce settlements across borders, which is essential in a globalized economy. Now, let's move on to Alternative Dispute Resolution, ADR. ADR refers to any procedure used to resolve disputes outside of court. It's becoming increasingly popular because it's often faster, cheaper, and more private than court-based adjudication. There are several types of ADR. Arbitration. An independent arbitrator makes a binding decision. Mediation. A neutral third party helps the parties reach a voluntary agreement. Conciliation. Similar to mediation, but the conciliator may propose solutions. It's also worth noting that arbitration is recognized in Islamic law, where it's known as tahkim. The arbitrator, or hakam, must be a Muslim, male, just, and knowledgeable in Sharia law. This highlights how arbitration is adapted to different legal and cultural contexts. Let's now look at the advantages and disadvantages of ADR. Advantages. Cost-effective. ADR is generally cheaper than going to court. Faster resolution. ADR processes are typically quicker than court proceedings. Confidentiality. ADR is private, which is important for businesses that want to avoid public scrutiny. Disadvantages. Limited enforceability. Some ADR outcomes, like mediation agreements, may not be legally binding. Lack of precedence. Unlike court decisions, ADR outcomes don't create legal precedents. One of the most important frameworks for international arbitration is the UNCITRAL Model Law on International Commercial Arbitration. This model law, developed by the United Nations, standardizes arbitration practices globally. Key features of the UNCITRAL Model Law. Arbitration agreement. The agreement to arbitrate must be in writing. It can be a clause in a contract or a separate agreement. Arbitral tribunal. Typically, 3 arbitrators are appointed, 1 by each party and the third by the 2 appointed arbitrators. Conduct of proceedings. The tribunal ensures that parties are treated equally and can agree on the procedures. If not, the tribunal decides. Arbitral awards. The final decision must be in writing, signed, and dated. It's binding and enforceable in most jurisdictions. Now, let's dive deeper into the arbitration agreement, which is a key component of the arbitration process. Definition. An arbitration agreement is a contract between parties to submit disputes to arbitration rather than going to court. It can be a clause within a larger contract or a separate agreement. Form. The agreement must be in writing. This can include a signed document, an exchange of written communications, e.g., emails or letters, that provide a record of the agreement. A reference in a contract to another document containing an arbitration clause. Key points. Parties can choose arbitrators. The parties have the freedom to select their arbitrators, which is a significant advantage of arbitration. Courts will refer disputes to arbitration. If an arbitration agreement exists, courts will typically refer the dispute to arbitration unless the agreement is invalid or unenforceable. Next, let's discuss the arbitral tribunal, which is the body responsible for resolving the dispute. Composition. Typically, the tribunal consists of 3 arbitrators, unless the parties agree otherwise. Each party appoints 1 arbitrator, and the 2 appointed arbitrators then choose the 3rd arbitrator. Independence and impartiality. Arbitrators must be independent and impartial. They must disclose any conflicts of interest that could affect their neutrality. If a party believes an arbitrator is not independent or impartial, they can challenge the arbitrator's appointment. Now, let's look at how arbitral proceedings are conducted. General rules. Equal treatment. The tribunal must treat both parties equally and give each party a full opportunity to present their case. Flexibility. The parties can agree on the procedures to be followed. If they don't agree, The tribunal decides how the proceedings will be conducted. Oral or written. Proceedings can be conducted orally, through hearings, or in writing, depending on the party's preferences. Key steps. Statement of claim and defense. The claimant submits a statement of claim outlining their case, and the defendant responds with a statement of defense. Hearings. If requested by either party, the tribunal may hold oral hearings for the presentation of evidence. Termination. The proceedings end with either an arbitral award, the final decision, or a termination order if the proceedings are no longer necessary. Now, let's discuss arbitral awards, which are the final decisions made by the tribunal. Form and content. The award must be in writing, signed by the arbitrators, and dated. It must include the reasons for the decision and specify the place of arbitration. Enforcement. Arbitral awards are binding and enforceable in most jurisdictions. However, courts can refuse enforcement on specific grounds, such as, the arbitration agreement was invalid. The award violates public policy. The arbitration process was flawed. Sometimes, a party may want to set aside an arbitral award. Let's look at the grounds for doing so. Grounds for setting aside. Invalid arbitration agreement. If the agreement was not valid under the applicable law. Lack of proper notice. If a party was not properly notified of the arbitration proceedings. Award beyond the scope. If the award deals with issues not covered by the arbitration agreement. Conflict with public policy. If the award violates the public policy of the country where enforcement is sought. Time limit. A party must apply to set aside an award within 3 months of receiving the award. Finally, let's discuss the recognition and enforcement of arbitral awards. Key points. Arbitral awards are recognized as binding in most countries. To enforce an award, a party must apply to the relevant court, providing the original award or a certified copy. Courts can only refuse enforcement on specific grounds, such as, the arbitration agreement was invalid. The award violates public policy. The arbitration process was not conducted properly. Practical differences. A setting-aside procedure is effective in all states involved in the arbitration. A recognition/enforcement procedure is only valid in the state where the party seeks enforcement. To summarize, court-based adjudication is formal and creates legal precedents, but it can be costly and time-consuming. ADR mechanisms like arbitration, mediation, and conciliation offer faster, cheaper, and more private alternatives. The UNCITRAL model law standardizes international arbitration, ensuring that arbitral awards are binding and enforceable. Arbitral awards are widely recognized and enforceable, but they can be challenged on specific legal grounds, such as invalidity of the arbitration agreement or conflicts with public policy. Understanding court-based adjudication and ADR mechanisms is crucial for anyone involved in business or corporate law. Whether you're dealing with a local dispute or an international commercial conflict, knowing the pros and cons of each method will help you choose the best approach for resolving disputes efficiently and effectively. Thank you for your attention, and I hope this session has given you a clear understanding of these important legal concepts. If you have any questions, feel free to ask.